Jordan is an associate at the Vancouver office of LaBarge Weinstein LLP, a business law firm catering to startups across the country. With experience assisting technology companies from ideation to fundraising to exit and all points in between, Jordan hopes he can pass along some of the legal do's and don'ts he encounters on a daily basis. Please welcome Jordan.
There we go. Thank you. Is this volume's good for everybody? Yes, thank you, Alana. Great intro. So yes, I am Jordan Potechin. I'm from LaBarge Weinstein. I think I'm sort of shocked that anybody would choose to come and listen to a lawyer for the next hour, but I'm hoping it can be as interactive as you want it to be. I don't want to feel like I'm just sort of talking at you for a while, so feel free to interrupt me. Do it. There we go. You ready to go?
Yeah. Can we either get a copy of those slides, or would it be all right if we take a picture of them for information stuff?
Yeah, sure. I mean, there's very little advice on there, and they're pretty slim. But sure, if you want to grab them, yeah, that's fine. Probably it's the contact details, if you want them, might be more helpful to you. So yeah, if you guys have questions along the way, if I'm going too quickly, whatever that is, feel free to stop me and ask your question. I did the sort of meet an expert thing earlier today, and most of the questions I was getting were around like technical stuff, copyright registration and IP protection. And so I will preface, I am going to talk about that a little bit today, but I'm a corporate lawyer who works with the licensing lawyers. So I'm happy to give you contacts for those specific questions. I'll do my best today to maybe answer some of that stuff, but my expertise doesn't stray into that territory. So what I will be talking to you about today are sort of the minimum viable legals, or what you need to know to start your company. I suspect with everybody being students, you're either thinking about starting a company. Maybe show of hands if you already have a company. A few people here, cool. And thinking about starting one. Few more. Okay, so hopefully the presentation will be catered to both groups. We'll sort of do it in chronological order. Those things you want to think about before you start, and then those things you want to have or think about once you've gotten started. So I would be in big trouble if I didn't do the intro to LaBarge Weinstein. So the partners would be very upset if I didn't plug a little bit, some shameless promotion. So we are a national boutique firm. So that it sort of sounds weird, but we are mainly based in Ottawa and obviously Ontario, just being the bigger province, so Ottawa and Toronto. We do have a smaller office in Vancouver that works with the West Coast and Alberta and those types of things. We have clients in every province. And we do this, and we do this pretty exclusively. So I think for 2015, we did the most venture capital financings of any firm in Canada. So we like to think that we're a startup firm, and we're sort of have a business model that assists with that as best as we can. We understand that there are always constraints on startups, and we try to help with that. And it's sort of I think an under-assisted zone in the law, just because the startups don't have a lot of money, lawyers cost a lot of money. So this is what we do, and we have a great team assisted, as I mentioned, by licensing colleagues, our corporate group, and a tax team to sort of provide that full scope of assistance for companies during their full life cycle. So I know Alana had touched on the ideation to exit. So we sort of see that as two ends of the spectrum. That can start with some of you just have what you think is a cool idea, and you're thinking about it either on your own or with a couple friends, and you want to make it a business. And so first step would be what does that business look like? And we're going to talk about that. And then you need to make money and hire staff and do these things all along the way until there's some kind of exit. So the best case scenarios are you get acquired for hundreds of millions of dollars, or you go public for hundreds of millions of dollars, or you may fail somewhere along the way. And we've seen sort of every end of that spectrum. So I'll just go back for sort of this agenda here. So that's the intro. When we're talking about getting started, so that's going to be just a quick overview of a few of the types of business structures. So obviously the overwhelming majority is an incorporated company, but there are some other options, and we're going to talk about a couple of the other ones. The next one will be the minimum viable legal. So that's going to be, once you've decided I'm going to do this company, I'm not going to do these other couple of things. How do I do that? When do I do that? Where do I do that? Because you've got some options there as well. We're going to talk about sort of initial capitalization. I don't know if anybody here is familiar with the term cap table. Probably if you already have a company, no? So that's just a handy Excel spreadsheet that shows who your shareholders are, how much of the company they own, and those become a very handy guide and something that founders love to see because they want to know what do I own versus what does everybody else own, and do I still have control of my company? And so we assist in sort of setting that up at the very early stages to avoid some of those pitfalls down the road. We'll do a pretty sort of brief IP discussion, and that's going to be mainly centered around initial protection, sort of as it pertains to the founder group and your first batch of employees, what you need to have in place to ensure that the company owns the IP and there's that chain of title. The investors don't want to invest in a company that doesn't own their product. So we like to get that out of the way right at the beginning and make sure that you own that. Part of those minimum viable legals, so shareholder agreements, that is the bulk of the questions we get at the early stage. And so that's just the written agreement between, I guess at the beginning, between the founders or among the founders that says, we own this company, these are our rights as shareholders, this is what we get to do as shareholders. And so that's a very important document and something that we see far too often. A company gets a year down the road and they don't have that, and there are issues associated with that. We'll sort of recap all that. I'll go through a few things in the up and running phase. So this will be most, I think, relevant to those that already have a company. So that's stock option plans, some employment and consultant type information, and then we'll do a bit of a dive into financing. I think most of the time companies want to know how they can make money, and there's a few different ways that we see in the tech space how that occurs. And then I'll show there's going to be a handy slide, the startup story, as sort of a best case scenario, and maybe some timelines that hopefully you're able to just keep in mind as you're growing your company. But again, it's a best case scenario. There are often deviations from that. And then lastly, I can sort of let you know some of the common questions that we get, some of the problems that startups face, and a bit of a Q&A. But again, stop me at any point and we can have an ad hoc Q&A at any point. So a bit more shameless promotion. So these are just some deals that we've worked on. Over $8 billion in M&As and $7 billion in VC financings in the last 21 years. So we are constantly busy. I think just this week we closed a few deals. So when it comes to the financing side, that's sort of our expertise. So hopefully I can share some information about that. All right, so moving on to the meat and potatoes. So the majority, as I said, is company structure, but there are some other structures that you can go with. So I've identified the two other, I guess, most common that we see. So sole proprietorships and partnerships are distinct from companies, and we'll kind of unpack those piece by piece. So sole proprietorships, that's if you are, this is a sole, one person and you want to start a business. The business is not separate from you. You and the business are one. It is not incorporated. There can only be one owner. And one of the main disadvantages and the main reason that companies incorporate is that sole proprietorships have unlimited liability. So if the company goes bankrupt or the business concept goes bankrupt, the sole proprietor of that entity is on the hook to the extent of their personal assets. And so that tends to scare a lot of people, I think, out of that route. But on the other side, there are some advantages. Business income is personal income. You can file one tax return and business losses can offset sort of personal tax issues. It's great for low risk or short-term businesses. You want to get insurance probably to protect yourself from some of that liability. And then the big one is you won't find too many investors willing to invest in a human being. They want to invest in that separate corporate entity so that you can't issue shares in yourself. So how would that look like if you've got somebody trying to give you money? And so there are pitfalls with that. And again, there's that personal unlimited liability. On the other side, no formal dissolution required, so there's no paperwork. You don't have to file anything, you don't have to register anything. It's the simplest form, so some people sort of like it for that purpose. Partnerships, as you may suspect, is for 2 or more people, and there are a couple different forms of that. So you've got general partnerships and limited partnerships. The general partnerships is, so that's just 2 or more people carrying on a business with a view to profit. You cannot have a not-for-profit partnership. There has to be a commercial nature to that business. And sometimes it's attractive. It's pretty easy to form. General partnerships don't need to be registered. Limited partnerships do. There's a general just lack of formalities. But again, as we talked about with sole proprietorships, unlimited liability for the partners involved. And that can be on what's called a joint and several or just joint liability. So if you and a friend start a business and that business goes bankrupt, you are both personally on the hook for whatever amount that bankruptcy entails. For limited partnerships, that is something that does require a little bit more paperwork. You have to register that, especially in BC, you register that with what's called the BC registrar. And that is distinct in that there is at least one general partner who operates the business, and then what's called a limited partner, who is sort of the money behind the operation. And so they can, I guess, identify what the level of their liability is through a limited partnership agreement, and typically that limited partner is only liable up to the amount of money that they put into it. There are situations where somebody would be named a limited partner, but they are operating the business. And so if ever there is a dispute, a court can impose that liability on that limited partner because they are acting as though they are a general partner.
Why would a business bother doing a partnership instead of a corporation?
Ease is usually, people sort of see incorporating as costly or a step that they may not need. And so that's probably the number one reason. Or they don't see it as being something that's going to make money. So me and a friend are just going to do this and it'll be a partnership. The limited partnership is that one step above, I guess, in terms of formality, in that you've identified yourself as a partnership with the government. But that's the main reason, is it's easier. And so, sorry, go ahead.
How many of the law firms are LLP?
So LLP is what's called a limited liability partnership. That is only available to professional services. So law firms, accounting firms, I think engineers can do that. And so the government and the people who write the Partnership Act have decided that these services, everyone can be a limited partner in this situation. So, and they're capped at, I think, whatever amount that they put in. So I sort of left that one out just because that wouldn't be available to, say, a tech startup. That's not deemed to be a professional service. So I think, to finish off that one, that's basically just, it's the ease of a partnership. It's not a separate legal entity as well. Those individuals, even though they've created XYZ partnership, they're still subject to that unlimited personal liability.
So if you just start with a website, start selling things on it, are you by default a sole proprietor, or do you do some paperwork to actually differentiate that you're not selling things?
No, it would be by default. I think if you're you've started a website and you're operating under a different name, without incorporating it, it is not technically a company. And so that business idea would be tied to you, and any revenue that you generate or any money that you get from that would be sort of deemed personal income as well. Any other questions on the riveting concept of partnerships? No? Okay, so we'll move on to companies because I think that's probably what most of you want to hear about. And so, as I mentioned, I kept sort of using this term unlimited liability. So the benefit of a company is that there is limited liability. And the reason for that is once you incorporate, you create a separate legal entity or separate legal person that is distinct from the human beings that run that. The company becomes liable for any of those debts or obligations, and generally any shareholders are, I mean, we use the term liable, but so they're liable up to their financial contribution, but really that just means if you take $100,000 from someone, you issue them shares, the company goes under, they've lost their $100,000. They're not on the hook for whatever outstanding debts may be in place when that company goes bankrupt. And so from an investor perspective, obviously they're looking for that. They know what they're getting themselves into. They've given you that money. If I never get that money back, they're, I suppose, willing to live with that. That's not what they want, but there wouldn't be any additional liability attached to that. And so there are formalities to it. They are created by statute. And a little bit later we'll get into kind of what that means for being in BC and what you can do in BC versus what you can do federally, and we'll sort of navigate that because there are some pros and cons to each. But the corporations allow for sort of free transfer of shares, flexibility in creating management structures. We'll talk about some of the documents that evidence that. And shareholders own the company. The board of directors manages or controls the company, and the board would then appoint officers that manage the day-to-day. So there's sort of three levels, and I know somebody was very keen on this in one of the questions earlier, whether that can all be the same person. So in a single founder situation or 2 or 3 founder situation, it's possible that all 3 of them are all 3 of these things. They are shareholders, let's say it's 33, 33, 33. They are all directors and they all hold some sort of office. So CEO, CTO, secretary, president, all of those things you can be, one person can be all of the officers. So there's some flexibility there in terms of how the business operates and how that's divvied up. So some more advantages. The protection of your personal assets is the big one. So if your company goes under, there are certain situations where directors can be personally liable, and I won't dive into case law with you. But for the most part, as long as you are operating the company in good faith, the company going under does not affect you personally. It may affect you emotionally, but financially, it does not affect you. There's easy transfer of ownership, so if you decide you don't want to be a shareholder anymore, you're able to sell those shares. You can get a lower tax rate, so tax will factor into this, just in case you were worried that this was going to get more exciting. It will, because we're going to talk about tax. Businesses are taxed at a lower rate, and that's, I think, to stimulate the economy and stimulate business, and the government wants people to create companies and create jobs and keep the world moving. Recruitment is a great advantage for companies. I'm sure, as some of our founders here can attest, there's not a lot of money to start out, but you can issue shares, you can issue stock options to employees or consultants, and those are the types of things that when you can't pay money right away, there's some skin in the game, and those employees tend to see that as a valuable, oh great, I'm going to take this job because I'm going to get 1% of the company or whatever percentage it is for my role, and so that's seen as a great benefit. As I mentioned, investors probably won't invest in a sole proprietorship, so there's the ability to raise money by selling stock. When we go into the financing, there's some other options as to how to raise money, but that's the main one. You can just sell shares of your company for a price and you grow your shareholder base. The other concept, and I know that this is probably what you want to hear, is the benefit is the IP bucket. The company gets to own whatever it is that you've created. So trademarks, the copyright, if it's a software company, the software is deemed to be a copyright. The patents, if that's kind of what the company is all about. So the company gets to own that as opposed to it just being sort of one person owning it. And so we'll go into sort of the protection of that in a little bit. And so for all of those advantages, a company tends to be the overwhelming favorite in terms of a business structure. We can sort of take a break. Does anybody have any questions before we go further into companies? All right. Go for it.
So let's say I have a patent and it's under my name. Can I transfer that to a company fairly easily?
Yeah. So you would sell that, and so oftentimes what we see are a founder or a group of founders that has been working on something before they've incorporated, and so there are tax advantages to that. So that's what's called an asset rollover, and my tax colleagues are far more well versed in this. But essentially, what you do is, if you believe that the IP has value, you can roll it into the company on a tax-deferred basis in exchange for shares in that company. So the founders, instead of just being issued shares by that company, they're in a sense selling the IP to the company for shares, but it's more of an exchange because there's no, you're not paying cash for those shares, but you've put a value on that by virtue of the idea or whatever product it is, whatever stage that's at, you've put that into the company and you've gotten some shares out of it.
You mentioned that companies get taxed at a lower rate than people.
Yes.
They're a separate legal entity. So if you're drawing a salary from a company that you own, does that mean your money gets taxed twice?
The employment income you would have on your personal income tax, and then the company, whatever income the company generates, that would be taxed separately. So I wouldn't see it as sort of being taxed twice. But I think you're taxed, there's withholding tax for the company, and then the employee or yourself would be taxed on wherever that income is in terms of those tax brackets at whatever marginal rate that is. I don't know if that helps you. I wouldn't see it, I guess it's, I don't think you're gonna be taxed twice, but the company would be taxed for what the operations that it does, and the employee or director or officer will be taxed for the money that they receive from the company. I think oftentimes you see founders don't draw a salary for the first little while, and so they're sort of riding on the shares that they own in that until they get to a financing stage. But the taxation, I wouldn't call it double taxation.
So if you don't want to draw a salary, but you still want to, pay for your rent,
Yeah.
Is there an option for a founder who owns a company to make money aside from selling shares as they go, or drawing a salary?
You can pull that out with share dividends. You'd want to be careful with that. If you're the only holder of those shares, it becomes a little bit easier. When you declare a dividend on a share, it's for all of the shares in that class. And the other sort of caution to that is, if the company is not making enough money to justify those dividends, then that sort of doesn't pass the smell test from running the company in good faith standpoint. I think I managed to condense a second year, and I think based on some of the faces, it's a second year law school course into about 15 minutes. We'll move on, I think, to obviously more relevant information. So we call it minimum viable legals. A lot of times we get companies, they've been going for a year, there's no paperwork. They say, well, I own this many shares, and he owns this many shares, and she owns this many shares. Nothing has been written down, and that can cause a lot of issues. So there are a couple reasons why we would advise and strongly recommend that you have these sort of agreements in place and paperwork in place. First is regulatory compliance. A company that has not filed its annual returns can lose their good standing, which means they can't receive money from investors. It can be a breach of investment representations. Sort of bad news there. The investor side, as we talked about. Sorry? With whichever province whichever province you've incorporated in, or if you've incorporated federally with the federal government. So there are, separate from tax returns, there are annual returns, I don't think it's expensive. I think it's like $100 a year to file these things. But it's just something to maintain your good standing, that you haven't been dissolved and you're still operating. Otherwise you get, it's called struck from the record, and you have to revive your company, and it's very scary stuff. And so investors also want to see these things in place when it comes time for hopefully your seed round, and you've got some institutional investment coming in. They want to make sure that everything, you own your product, so you got the IP side, that the cap table makes sense, so the people that say that they are shareholders are in fact shareholders, and there is documentation around that. And all of this goes into what's called a minute book. We have moved into the 21st century, and they are now virtual. They don't have to be a paper book. And typically, if you go with a law firm, that would be sort of kept by them and maintained by them, and they would ensure that you've got what you need. So you've decided to incorporate. The next two questions are when and where. When is very much a cost-benefit analysis. It does cost some money to incorporate. I looked it up today just so that I knew that the stats were current. If you were to incorporate in BC, it costs about $400. So you need to get your name approved, whatever you've decided your great company name is going to be. You get that approved, and then you file what's called an incorporation agreement. You get articles back, and you're set up, and you've got your company. If you do this federally, it's about $200. So you don't have to go through a lawyer to do this. I suppose selfishly you should, and I should be the one that does it, and I'll give you a card, and we'll talk later. But you don't have to. It's very user-friendly. You can go online, and you can do it yourself. And a lot of times that's what we see. We'll get a phone call from somebody who has incorporated themselves, and they've gotten to a point where, okay, now I don't know what to do, and now I need some help, and that's totally fine as well. Again, the partners would be upset if I didn't mention that LaBarge Weinstein offers a $1,500 startup package where we would incorporate and get you set up with a lot of the documents that we're going to talk about. And we've sort of costed that out, and we have a great corporate clerk group that does it. And so we're able to do that relatively cheaply in the sense that if you're going to pay $400 to do it yourself and you only get one piece of paper, you pay the extra $1,000, and we can kind of arm you with that ready-to-go minute book. And then you go out, you create your product, and you do your thing. Yes?
So if it's, it was 400 for BC and then 200 federally, does it not make sense as a sole proprietor to just incorporate federally then, or does it depend on the type of business that you were doing?
Less on the type of business and more on, there's some residency issues. So BC is the only province in Canada that if you are a non-resident, you can incorporate. If you are incorporating federally, at least a quarter of your directors must be Canadian residents. So we often see BC companies are subsidiaries of American companies where they just don't want to have anyone Canadian involved. And people in BC just think, okay, well, I'm in BC and I'm only going to operate in BC, so that's fine. And so they'll incorporate that way. If you incorporate federally and you are operating in BC, there's an extra step of what's called an extra provincial registration, and that just allows you to do business in that province, and you would register in each of the provinces that you are doing business in. And normally that doesn't just mean like, oh, you have one customer in Alberta. You don't need an EPR for that. If you have like a base of operations and some employees or an employee or something in one of those provinces, you should likely have a registration there. And we always advise federally if we can help it. It's just a more familiar form, especially from an investor perspective. For whatever reason, BC has gone rogue with their Corporations Act. All of the other provinces look very similar to the federal statute. BC just, they do things a little bit differently. So the articles of incorporation look different. It's a little bit more strict on, I think again, it's very clerical, but sort of how you alter your articles is different on the BC level. But there's nothing sort of, I shouldn't say wrong, but you can incorporate in BC and then become a federal company. you wouldn't want to go the other way. But the BC thing tends to be, well, I live and I work in Victoria, and I'm never going to leave, my business is never going to leave here, so it's just easier for me to do it that way, is typically what we see. I don't know if that answers your question, but hopefully it does. Sorry, I lost the Wi-Fi here. Hold on, there we go. There we go. No, I got it back up.
Got it?
Okay, cool. So the next, and this is a great segue, where to incorporate. So as we mentioned, there are residency issues. I won't go through those again. BC also has this great program called eligible business tax credits. And so if you are a BC company, you register with the EBC sort of regime. And if you have investors in BC, they are able to claim those on their taxes, I think on a dollar for dollar basis, up to a certain amount. And EBC works out that number with each company. So depending on the size of your company and how much money you're raising, the BC investors get a nice sort of kickback on that. And it's a great initiative, I think, by the BC government to have BC investors support BC companies. So another sort of advantage than the federal side. The federal issue, so I guess overarching all that again is tax. So I'd mentioned 25% residency to incorporate federally, but if you are, so the awkward legal drafting is not less than a majority. So that means you can have 50%, you don't need to be 51%, but if 50% of your board, so 2 of 4 is fine, 2 of 3 is fine, and 50% or more of the shareholders that have the ability to vote that board are Canadian residents, you are what's called a Canadian Controlled Private Corporation, or CCPC. And that's a function of the Tax Act. And I think everyone just fell asleep when I said that. But you get eligibility for shred credits, which is very sort of a hot topic in the tech space. There's a lifetime capital gains exemption up to $800,000, and so there are some advantages to having that CCPC status as well. But you can be eligible for that whether you are a federal or a BC company. So when you're starting out, the next question we get is how should I incorporate? What should the share structure look like? We tend to, and I definitely agree with it, is the sort of keep it simple model. A single class of common shares is the vanilla form to go with. A lot of times you'll get founders asking, I want to hold the voting shares and I want everyone else to hold non-voting shares. And that's something you can do, but there are problems with that as well. Separate share classes carry class voting rights, and so typically we advise against that. Just when we talk about shareholder agreements in a little bit, you can get through all of those voting and non-voting issues with just a well-drafted shareholders agreement that keeps control with the group of people that want to maintain the control, and the people that are there just to sort of pump the money in, they have sort of less of a vote. Division between founders. So that tends to be one of the main sources of tension down the road. If you have 2, 3, or 4 people and they start out thinking, okay, we are going to contribute equally to this. So we are 50-50 owners, and then 6 months later, someone is not holding up their end of the bargain, there can be issues there. And so we try to navigate that with founders as best we can. And the shareholders agreement is a great way of doing that, where there are certain sort of mechanisms in place that if a founder decides to leave, the other founder maybe absorbs those shares and can continue operating. Restricted stock and vesting. Has anyone heard the term vesting? All right, so you guys will run the show, I guess, for the rest of this. I'll stop talking. So the vesting is a great way of incentivizing founders and your staff. What that means is you will get shares, but you need to work for this company for X amount of time in order to fully realize that amount. So what we see at the very early stage is what's called restricted stock. and that is subject to reverse vesting. So you will be granted, say, 100 shares, but you will get those 100 shares after you work for the company for 3 or 4 years, let's say. And if you leave at any point along the way, you only get to keep what has vested. And so that can be on a monthly schedule, a quarterly schedule, whatever is sort of negotiated. The standard is 4-year vesting, and the vesting kicks in after 1 year. So you have to at least give us a year before you get the first 25%, and then you get the rest monthly or quarterly. And so if you stay there for 4 years, you get the full 100 shares. And this is something we see not just with employees. It's something that investors also impose on founders. So if founders have not vested their own shares, usually at that first financing, the investors will say, okay, great, we're investing in this team. We're not just investing in the company. And we want to make sure that these key employees that we've identified, and that's usually the founder group, we want to make sure that they stick around. So we're going to make sure, even if they weren't vested before, we're going to give you the credit for what you've done so far, but we want to make sure that the next batch of shares is subject to some kind of vesting schedule to make sure that you stick around. And again, I think I touched on the ability to repurchase. So that's can be a sticky thing. You want this employee to come in, you think that they're great, we're going to give you X number of shares, and then they leave. And you don't want that person to hold those shares. And so there's a repurchase mechanism that's in place there that the company can claw some of those shares back. So nominal pricing for shares, again, this is a tax thing. So nominal pricing just means you can issue 100,000 shares for $1. There's no real value to them because an early stage company doesn't really have a value. The value comes in later when you have a third party that has decided, okay, I'm gonna give you X, I'm gonna give you $1 million for 25% of your company. Therefore, your company is worth $4 million. And at that point, once a third party has established that value, you're no longer able to issue those shares on a nominal basis because whoever receives those shares will be taxed on that difference. And so when we get into stock option plans, that's where that comes in. There's some better tax treatment on options for the people that receive that. Any questions on initial capitalization? Clear as mud. So the basic IP strategy, this is something that I've attempted to pick up along the way from my licensing colleagues, and I'm hoping that everyone will have a question on this so that I can keep saying I don't know. But the gist of it is the company should own the IP. Whatever that IP is, the company should own it. And so a few of the great ways to ensure that that's the case. So we've got NDAs and CIPA. So NDA is a non-disclosure agreement. Typically, if you're a company that is engaging with a customer, you would enter into an NDA that says, okay, we're going to talk about what each of our companies do. And what I tell you is confidential and what you tell me is confidential. And at the end of the day, we still own our respective products. And even if we don't end up kind of doing business together. The CIPA is it's a confidentiality and intellectual property assignment agreement, and that's something all the founders should sign and all of your staff should sign. So whether that's an employee or a consultant, anyone that is providing a service to this company and creating something for the company should be assigning that to the company to ensure that there's ownership. If you encounter a consultant or an employee who says, I don't want to sign that, you can assure them that it is very market standard. Every company would have this in place. And there are even forms out there that if they're concerned that especially on the consulting side, if they're kind of doing their own thing on the side, which most developers are doing, you can carve out. So I'm going to do this other thing on the weekends or at night. It has nothing to do with what you're doing, and we're going to list that out. And you don't get to, the company doesn't get to own that. I get to keep that. But what I do for you, you get to own. And so those are just sort of great mechanisms to ensure that chain of title.
We kind of default just say all the work that you do during your current period belongs to the company. Is that the default, or like?
Yeah, basically. So there's a couple different things. What the knowledge that you gain from the company is confidential, and you're acknowledging that it is confidential, and you're not going to go around and tell the next company that you work for what they're doing. And then the proprietary property that you create, so the work that you do, sometimes there's like a normal business hours kind of carve out. So you're going to work for this company from 9 to 5, Monday to Friday, and what I do using the company's computers or what I do for the company is owned by the company. It gets a bit tricky, I think, because everybody works from home now and everybody's got their own laptop, and I think a lot of companies are cool with that. But that's where we typically see that language of what you are doing for the company belongs to the company. And if you want to exclude anything from that up front, that you've already created these things, let's just list them out, and then we're going to acknowledge, yep, we don't own that, but everything that you do for us, you would own as well. And I think I had a great question from Josh, there he is, earlier, just about sort of finding these forms online. And so one of the things, you can find these forms online. Just be careful about using an American form. They have a different intellectual property regime, and they have what's called works made for hire. And it's just not a concept that we have in Canada. So you just want to be careful that the agreement that you're just pulling off from the internet because it's cheaper is applicable to Canadian law. And so if you come across the term works made for hire, that is an American concept. It kind of deals with that same idea of what you create for this company is owned by the company. And so more often than not, it's again a cost-benefit analysis. So you want to, and this is in the context of registration. I got a ton of questions about registration earlier today as well. Trademarks, patents, and copyrights can be registered. In Canada, you don't have to register them without, or you can assert ownership over those things without registration. And those are called common law rights. And so if you have a website, I think you mentioned you're going to start a website, you're working on your own, there's probably a name of that business, and there's probably a logo. If you can sort of assert rights back to a certain date, you own it back to that date. And so without registering it, you can register it, and that's a stronger, I suppose, defense of that. But it is expensive. I think trademark registration is about $3,500 to get a lawyer to do it. And I would recommend that if you are going to go that route, that you do, because there's a lot of paperwork, and patent infringements, or patent registrations even more so. So if you are operating, you don't need to worry that you need to register your trademark right away because somebody's going to come and steal it from you. Obviously, if you start operating this website and you put your logo up there and someone else has been using it first, they may tell you to take it down, and you can kind of fight about how similar it is and fight about whether they used it first and that kind of thing. But if they have a genuine claim against that, then you're likely going to have to take that down. You can obviously coexist if you're operating in different enough spaces, and you can come to some kind of an agreement where one party would license it from the other. That's okay as well. But those are the types of things that you just keep in mind. You don't have to do it right away because it is expensive. And the other thing, and this is not to sort of make anybody feel bad, but when you start out, anybody who wants to sue, you don't have any money. You're not sort of worth the infringement claim. So typically what ends up happening is people will come out of the woodwork just as you're starting to make money. And so that's likely the point where you might want to register if you're concerned that there might be something else that's similar out there.
It's called common law.
Just so common law rights to just common law IP ownership. So, and common law just means not based in statute. So you own that without it being registered under some kind of legislation.
So if you look at a company name and you find the .com version of it, like how can you make sure that that's not infringing on someone else's company name somewhere? Like, is there some tool that you can search it on?
Yeah, so you can definitely search registered IP. So the Canadian Intellectual Property Office, CIPO, has just a search function on their website. And so you can go through all the different iterations of what you want your name to be. It's a little harder, I think, to search for a logo if there's no word in the logo, but you can definitely search those things online. You can do that for Canada, for the US, EU, Australia, wherever it is that you want to register, you can definitely search those things out. In a Google search, if you're thinking of naming your company XYZ, you just search that and see if there's another XYZ. And something that I touched on, I think, with one of the questions earlier, when you are doing those naming, it's typically phonetic, so you can't just say that you're Google with an extra O. That's not going to fly. I think I just encountered a company that wanted to incorporate a certain name, and the same phonetic name was out there, and the spelling could not have been any different, or not, just completely different. But they ended up having to add what's called a descriptor word, and that's something you can sort of include. So if you want to be XYZ, but there's another XYZ, you can be XYZ Technologies, and that would be distinct from XYZ Mining, XYZ Gaming, XYZ Consulting. And so there are ways around. If you're really into that name, there are ways of avoiding that confusion. All right, so shareholder, maybe before I move on, any other, IP questions that I can butcher? Okay, cool. So shareholder agreements. So we touched on this at a few points. So this is probably the most important agreement for a startup to have early on. If you have more than one shareholder, you must have this. This would govern the relationship between however many founders you have, and it governs the relationship between the company and those shareholders moving forward as you grow that shareholder base. We would recommend a pretty simple version to start. Oftentimes the ones that you pull off the internet are 30 pages, and they include every possible thing, and those are likely not useful at an early stage. I think the form that we use to start out is 6 pages, and it covers, as we mentioned, so corporate governance and share issuances and transfers, and that's kind of the basic of what you need. Those basic governance and share issuance kind of things, the basic concepts. So board structure, if you have 3 founders and you want 3 seats on the board, your shareholders agreement would say that. These 3 people have the ability to nominate a director to the board by virtue of them being shareholders. And if ever that person transfers their shares to someone else, that board nomination power would then transfer, or could then transfer, to that person. You see that often as a company grows. As investors come in, they put in money, they're going to ask for a board seat. And so the shareholders agreement is then amended to include that type of relationship that says, I hold X number of shares, therefore I have the ability to nominate a director. Information rights, so that deals with financial statements. Again, this is something that you're going to worry about at a later stage, but as your investor and shareholder group grows, they're going to want to keep tabs on the business. So that's something you'll see in a later stage shareholders agreement. Just on a quarterly and annual basis, you're going to let the investors know this is what's going on with the company. So ROFR stands for right of first refusal. And so what that means is if at any point one of the shareholders wants to sell their shares to somebody, the existing shareholders get first crack at those shares. And preemptive rights, kind of similarly, if the company wants to issue more shares to anybody else, the existing shareholders get first crack at those shares. So I think we're running pretty over time, I noticed. Does anybody have any questions on that? So we'll try to do this. So I think this is probably most helpful for the ones that are already operating. But as you mentioned, with stock option plans, once your company has a value and you still want to incentivize that staff, you wouldn't want to issue them shares anymore. They would receive pretty unfavorable tax treatment. And so what stock options allow you to do is you grant them an option to purchase shares at a later date at a certain price. And that's called an exercise price. And assuming that that exercise price is equal to whatever the fair market value of the company is at that point, they get to lock in that price and exercise those options into shares at a later date. And so they get that benefit, and they're not taxed until they sell those shares. So if you issue those shares instead of options, you're taxed immediately, and that's considered employment income. And so you're taxed at that same employment rate. With options, you get to defer that tax, and if it's a CCPC, as we talked about, and if it's issued at fair market value, they get capital gains-like treatment, and they're only taxed at 50% of the benefit. So there's quite a few advantages to those stock option plans. Again, you wouldn't have that set up right away. That would be something you'd set up as your company is growing and as you're receiving money from sort of external sources. Employees and consultants, there's a big difference between the two. So oftentimes you'll see consultants at first. So the company, if you hire employees, that is governed by statute, and you need to be paying them minimum wage. They need to have certain termination rights, vacation rights, those types of things. Consultants, that arrangement is simply governed by the contract between the two. So it can be terminated at any time. The consultant has to deal with their own taxes. There's no vacation obligation. So that there's sort of a benefit to both. But I think oftentimes we see early stage, you'll go the consultant route just so that you don't have to set up some of those in the infrastructure to have employees. Any questions on that?
Downside to the current consultant role?
I think there's I guess less control over the relationship. The employee, I think you have a little bit more certainty over the role that they're providing for you, and that sort of intellectual property assignment. You would have a consultant sign something similar, but with those consultants, they're sort of probably working for multiple companies, and so there's, I guess, a bit more of a risk there. But typically we see it's like consultants until your company is big enough to have employees. And then at that stage, and I think from a staff perspective, they want to have that job security, that they're sort of locked in as an employee as opposed to a consultant. And I think sort of lastly, the fundraising. So we'll sort of quickly cover it. So there's the spectrum of debt and equity. So shares are equity. And those are just, you can sell shares, and as we talked about earlier, we can issue shares at the early stage. Debt is a future obligation to repay that. So with a share, there's no obligation to pay a shareholder back for what they've paid you for those shares. They hold those shares until they sell them. With debt, and that can look sort of differently. So there's notes, debentures, warrants. There are convertible forms of those, any number of things. But what separates the debt from the equity is that obligation to repay. And there are some hybrid forms. I know tech companies are constantly raising on what's called a SAFE. Has anybody heard of a SAFE? No? So that's a simple agreement for future equity. And it's become very popular in Silicon Valley. I think Y Combinator was the one that came up with it. And so a lot of companies love that because there is no future obligation to repay. There's just a future obligation to convert it to shares. And so it's for your balance sheet, it's not debt. And so that's also sort of a favorable thing. And so we see that often early stage. You're not ready really to issue shares. You don't have a broad enough investor group. So you do a safe round with friends and family and raise that whatever minimal amount of money you need to just kind of get you through the next 6 months. And so that's what we commonly see are those convertible type of financings. So this was that great best case scenario slide that I had told you about. So don't be alarmed if this does not apply to your existing company, but this is sort of a best case scenario that I think if you're able to follow those timing milestones, you're obviously in great shape. So in the first month, ideally, and this very rarely happens, we usually I've been running my company for 1.5 years and we don't have anything. So by day 30, if you've got all these in place, you're great. If in the first year or so, you've been accepted into some sort of accelerator or incubator type space and you've got some financing and you're starting to meet the right people, that's great as well. Sometimes that doesn't happen until you're a year out. The product launch and you're sort of hitting those financings along the way, So that $500,000 to $1 million financing, that's usually what's called the angel round. Maybe that's shares, maybe that's still some kind of convertible debt. And then the $1 million round, maybe that's your seed round. And so typically you're going to be valued at a certain number, and they're going to come in, you're going to be valued at $5 million. And so you're going to raise $1 million and give up 25% of your, or 20% of your cap table. And then the $3 to $5 million, that's usually your Series A round. Again, this may seem pretty far into the future for a lot of you, but those are the typical timelines that we see with those financings. So some of the common questions that we do get, and I guess some of the dangers that we face is template forms. So we provide you with a template form of employment agreement or one of those IP assignment agreements. And then you go out, we don't hear from you for a few months, and you go out and you make all these changes to it and you get somebody to sign it. And we can't sort of stress enough that keeping those forms all uniform is key. As you deviate, it's harder to, I guess, discern what obligations you've made to different people. So that's something we certainly come across with. We provide the sort of just keep it the way that it is, and then inevitably it'll come back with certain changes. So try to avoid that as best you can. Every document is a negotiation, but do your best. And then the other one is not talking to the company lawyer. Because every time you call us, that probably is going to cost you some money. I know the conversation that we had was on a no-cost basis. This is not going to cost any of you anything either. And so, again, I can't stress enough, it will always cost you more in the long run to avoid the legal cost up front. It costs a lot more to clean up what you've done for a year than it is to just have done it right or properly in the first place. I know that that's probably hard to think about when you have no money and you don't want to pay for these bills, but that is certainly something to keep in mind, and you get to make that decision as you're running your company that if I don't have the money, how can I possibly do this? But it will always cost you more in the long run. Any questions, just at all? Happy to answer, and I'll be sticking around for the appetizers and networking if anybody has questions after.
I'm just going to plug LaBarge Weinstein. Group uses these guys, and I've done incorporations for $400. Yeah, it's super easy. But $1,500 to do all the docs that they do for you is a hell of a deal. It is the cheapest thing you will do with your entire startup, and it'll save you so many problems. You have no idea the problems you're going to hit until you go back to those documents that you signed years before and they help you with. So it's a smoking deal. And you guys have also got some very creative billing.
Yeah. I didn't want to sort of inundate you with the shameless plugs, but because we work in the tech startup space, we understand those cash constraints. So we tend to offer, we don't offer it for free, but we offer what's called deferred billing. So there's that $1,500 startup package, and we know, that's sort of minimum what you're going to pay, but we're not going to bill you as soon as you pick up the phone the next time. We're not going to send you that bill at the end of every month. We understand that you have to have money in order to pay us money. So we tend to defer that to your first financing. So you take these documents, you run with them, you work on your product, we'll deal with the legalities, and when it comes time, you're like, okay, well, I'm going to run out of money, should probably raise some money. You're going to come back to us, and we're going to help you with that as well. And when you get your check for $500,000 in the bank, that's normally when we'll come knocking and say, oh, remember all those great phone calls that we had? Well, they weren't free, and we're sorry about that. But we're not going to send you that bill when you don't have any money. And we're also pretty flexible about payment plans. If you don't want to pay us whatever that full bill is all at once, we can talk about it. If you don't feel like you got great value, we can talk about it. We're not sort of stuck to all of that. So I'm sure James will kill me for saying any of this stuff, but he tends to be the most flexible, I think, with those types of things. So we don't work for free, but we like to think that we work with you to get you the best deal and get you the best service. So again.
There is one question here on the app as well. I think
Excellent.
you did cover it in your talk, but maybe just to go over it again one more time.
Sure.
What specifically does it mean to incorporate a company? Just
to define that?
Is there, whoever asked that question, as opposed to, is there something else that they had in mind? No. So I think that you wouldn't incorporate, you would incorporate a company and corporation are interchangeable. And so the term company is what is used for when you formally incorporated your business, you become a company, and that's what distinguishes you as that separate legal entity. If that helps, whoever asked that question. The ghost is. Okay. So again, my name is Jordan. I'll be hanging around for a little bit. If anybody has questions that pop into their mind later, I'm happy to talk to you. Thanks.